Good evening. I'll call this November 13th, 2023, meeting of the Crystal Planning Commission to order. My name is Joe Selton. I serve as the chair. Just a reminder to silence cell phones and other electronic devices. First is I get some feedback here, so if I stop. First is a roll call. With the city planner, please call the roll.
Yes, good evening, Mr. Chair, members of the commission. Sears?
Here.
Heigl? Strand?
Here.
Selton?
Here.
Maristani?
Present.
Buck?
Here.
Einfeld Brown? Johnson?
Here.
And Schultz.
Here.
Chair, we have a quorum.
Thank you. Next is approval of minutes. The minutes from Monday, October 9th, 2023. Would someone like to make a motion to approve the minutes? Commissioner Schultz,
I make a motion to approve the minutes as written.
do I have a second?
A second.
Commissioner Strand, seconds it. Any corrections, additions? Not seeing any. All those in favor say aye.
Aye.
Against, nay.
And I abstain.
One abstention. You want to take roll
I
call?
also abstain.
Two. You want to take roll call? Yeah.
Sure. Sears?
Abstain.
Strand?
Aye.
Selton?
Aye.
Maristani?
Aye.
Buck?
Abstain.
Okay. Johnson?
Aye.
And Schultz.
Aye.
Motion approved.
Next is a public hearing. Before us is a subdivision request for approval of a common interest community CIC plat at 6613 36th Avenue North, application number 2023-08. The process of the public hearing is as follows. I'll open the public hearing. The city planner will present a summary of his report, and commissioners may ask questions of the planner. Then we will hear from the applicant, and commissioners may ask questions of the applicant. After that, we'll invite public comment. If you wish to speak, you need to sign up on the green sheets in the entryway. Hand them to the city planner, Mr. Olson. When you come up to testify, you must state your name and address for the record. If you have any materials to hand out, please give them to the committee clerks so that they can be distributed to the commission and entered into the record. After the public comments are complete, I will close the hearing. The commissioners will deliberate and act on the application before us. If there's a split vote, the planner will take the roll. I'll open the public hearing. Mr. Olson, you have the floor.
Yes, I do have a presentation. Yes, as said, this is a public hearing for a CIC plat, commonly called a condominium, at 6613 36th Avenue North. Here is a general location of the property, here in blue, and the area in the pink circle is the area where we sent a public hearing notice to. We also published the notice in the Sun Post, posted it on the city website, and a sign on the property. And we also posted it to all neighborhoods on Nextdoor. Here is a recent aerial photo. This is from 2022. Shows the two-family dwelling under construction at that time. So the applicant and the property owner is JUFH Enterprises, LLC. The owner of that LLC is Mahmoud, I'm not sure how to pronounce your last name. Abumi Valley, okay. Who is requesting approval of a CIC plat, a condominium plat, or condominium, I should say, for a two-family dwelling at that address. It will continue to be, the building will continue to be on one lot, so there's no land division involved in this CIC plat. The CIC plat will allow each unit, each of the two units to be sold separately, but there's, as I said, there's not a division of land. The units are currently addressed as units A and B at that address, 6613 36th, and that will continue to be the situation. Here are recent photographs of the two-family dwelling. This is what it would look like if the CIC plat is approved. So there would be no change to the exterior of the site or to the building. This is the CIC plat. It's made up of two different elements. First is called a site plan. It just shows the building, the two-unit building there on the property with various easements on the property. And then the other element is a floor plan. So there's the basement floor, there's the first floor, and the second floor. This shows the entire building, and so you can kind of see that the drawing shows the division of ownership within the building itself. So it's not a division of land, as I said, but it's a division of ownership within the building, sort of splitting it into two different ownership. The recommended findings for this CIC plat is first of all that the proposed CIC plat is a division of ownership, not a division of land. The UDC, Unified Development Code, does not have specific criteria for approval of CIC plats that do not divide land. Hennepin County does not require city approval of a CIC plat. Under state statute, the applicant could record the CIC plat without city approval. And then just lastly, as you saw in your packet, the city attorney has indicated that state statute may preclude the city from denying approval of the proposed CIC plat because it would be treating this development differently than other two-family dwellings. So staff is recommending approval of the CIC plat at 6613 36th. Before I get into any of your questions you might have, the city attorney would like to make a few statements next.
Mr. Chair.
Yeah, City Attorney Troy Gilchrist.
Thank you, Mr. Chair and Commissioners. Good evening. This is a bit of an odd situation legally, so I was asked to come in and just try to explain this. Because frankly, in my 9 years working here, I don't think I have seen a CIC condominium plat come through. So it's not something that the city deals with very often. And it's just unique because there are different kinds of CIC plats, and I'm not going to go through them all, but I work in some communities where these are regular divisions of property. So just like a subdivision, it's just they're subdividing their property, the real estate, into separate lots, into units that are sometimes separately owned. So it looks and walks and talks just like any other subdivision. Frankly, that's why you'll see zoning ordinance say a CIC needs to go through the subdivision process. That's what your ordinance says, and that's why we're here this evening. But technically, if you really drill down, a condominium CIC is really just an ownership division. It's not a dividing of even the structure. Well, it is dividing of the structure. It's just as far as designating the unit boundaries, but it doesn't divide the real estate. It doesn't do any of the typical subdivision stuff. And so, I mean, this would be similar to adding additional owners onto your property. You get married, you want to add your spouse on, that sort of thing. Someone passes and the kids end up owning it in thirds or something like that. So this is all just ownership stuff. And that's why, frankly, the county doesn't require local approval, because it's just changing ownerships just like a transfer of property. But our code currently does not distinguish between property division CICs, the traditional kind of subdivision looking real estate division, versus just this ownership sort of division. There was an attempt to clarify that a while ago. That went through a petition process for a referendum, and so that stopped. The council decided not to move along with that, but that was one of the clarifications that were in that long ordinance that that you folks saw some time ago. But that's the way it is, and so, but because it's still in there, the thought being you should run through this approval process because technically it's in the definition of subdivision, so it should go through this process. But again, the problem is we really don't have any standards in here because this isn't a division of land. Even the statute talks about these condominium plats are not subject to the typical platting statutes in 505 because again, you're not going to set boundary markers and things like that you typically would with a land subdivision. So it expressly exempts it from the typical platting requirements. Now, because this is not a policy issue, this is not a change to the ordinance, this is not a change to the comprehensive plan, this is applying the code to, such as it is, to the application before you. That's called a quasi-judicial decision, and ultimately that's subject to review on a rational basis test by the courts. And so you really have less discretion when it comes to quasi-judicial decisions because this isn't what I think is best for the community generally, you know, those policy sort of decisions that you make. This is much more, how does our code apply to this request? Well, as I said, our code really doesn't say a whole lot about this other than it lumps them generally in with a subdivision. So we're running through this process, but as I pointed out in the memo, the law specifically says you can't discriminate against the CIC form of ownership. You know, we don't want you here is not a legitimate response to someone saying, I want to create a CIC sort of ownership. That's really, the legislature protects these as saying you can't get involved in either prohibiting them or adding conditions to them that would be different than other similar sorts of developments. So as Dan said, this is a two-family dwelling. We really don't have any requirements that apply to two-family dwellings other than you have to comply with the building code and some of those general standards. So you really are in this unique situation where frankly, you know, but for that clarification that CICs our subdivision, it should be CICs involving the division of real estate are subdivisions. But because we don't have that focus on real estate in the code, it just gets lumped in with the definition of subdivision, which means we're kind of dragging them through this process without really any standards other than we got to take you through this process. And so lacking standards, really the only thing you have, I certainly know that there's opposition to this property having been developed in the first place, but it is. And that's not before you this evening. There's really nothing about the structure itself that's before you. There's nothing about the property itself that's before you. It's simply this property division, or excuse me, the ownership division. And so given that, there's really not a lot of discretion here. The statute says you can't prohibit, you can't add additional conditions to it. 505 doesn't apply. So it's just one of those things that we got to take it through this hearing process. You got to hear from the public. But in my opinion, there's really no discretion here. I changed that to may have, the statute may require it. I don't see much discretion here. I mean, this is just one of those things you have to run through the process. So I'd be happy to answer any questions if there are any.
So does that mean we don't have to vote on this because there's nothing we can do on this?
Mr. Chair, no, it's not that you don't vote on this. You still have to check the box and forward this on to the city council. But it's not that you don't have a vote. I mean, sometimes you're in a position of we just have to move this along. So it doesn't take you out of the voting situation. It just tells, I'm just telling you, there isn't much discretion here.
Any other question? Oh, Commissioner Schultz.
So who would own the real estate?
The real estate is owned by the folks that own the property. So but the real estate isn't divided. So one person will own unit A or B, however they divide it. Another person would own unit B.
And then somebody would own the real estate.
Well, the real estate is usually then part of the CIC. I mean, I can let the applicant speak more to what specifically he's talking about, but typically then that's common element that then is the responsibility of, you know, if it's big enough, there's an outside company. I live in a condominium. You know, I don't sweep the hallways. Someone comes in and vacuums the hallways and does that maintenance. So we're big enough where there's someone that's hired to do that. In a smaller condominium, I could see where the two unit owners are responsible for sharing maintenance of the common ground.
Taxes?
the taxes, typically the taxes are assigned by unit. So, I mean, there would be separate PID numbers typically, but it doesn't divide the property. So the PID numbers are assigned for tax purposes. So certainly I pay my taxes on my unit, the neighbor pays the taxes on their unit.
Commissioner Sears.
Okay, taxes are to the unit, but the ground, is that, you know, the real ground? Who pays for that tax, or is the county just cuts that in half and still assigns it to each one of those units?
Yeah, when it gets to that level, I'm not exactly sure how that goes. Again, the owner can maybe speak to that.
Okay.
But so you certainly pay, property taxes are paid.
Right.
And so so again, the owner can speak to this, but so it's either paid by the units, divided by the units, or it's paid on the common elements and ultimately paid by the two units, because each, you know, you have HOA fees typically, so you're paying part of that as part of your HOA.
Okay, so this is gonna be besides making your monthly payment to pay off the condo, you gotta make monthly payments for this small association then,
Yeah, and
potentially.
yeah, depending on how it's structured.
Right.
Again, I can tell you as a condo owner,
Yep.
yes, that's what you do. You pay your mortgage, and then you pay towards the HOA, which then I think typically pays the taxes on the common elements.
Okay, now, one more question, then, you know, what happens if you buy a duplex? Can a person who buys a duplex that's already in the city and then follow through on and put the duplex up for condo? Has that been thought of?
Yeah, so, Mr. Chair, so you're saying, say, a building that was built 10 years ago as a two-family
Yeah, there's
dwelling?
a bunch of duplexes in this city that are
Right.
50 years old.
Right.
Somebody buys them up and then subdivides them like what's going on here. Can that be done? Or once that was platted as property to a duplex, it can't be undone?
No,
I'm just thinking out of the box how things
Sure.
can go.
Sure. Yeah, Mr. Chair and Commissioners, my impression that the language that I talked about that prohibiting this kind of ownership would in my opinion, say, no, you can't stop that. So yes, they could do that.
Okay.
Because that's,
what I figured you would say. 'Cause
Yeah.
I read the other handout that said you can't, you know, what you said, you can't
Right.
stop it.
right, yeah.
Okay.
Yeah, I mean, there really is this protection for this type of ownership. I mean, you see this sometimes in larger communities where there's a lot of apartment buildings. Someone will come in and take what has been a rental apartment building for a long time, and they turn it into condo units. So again, not dividing the property, they're just dividing vertically those units within this floor.
Okay. Different avenue that we gotta think about, okay.
Commissioner Strand.
There's a lot in my mind right now. So this is a 2-unit, it's a twin home, let's be honest with it, it's not a condominium. And when I looked up, thank you for sharing the 515B, I went and looked it up. And it does have to be administrated by an association, so association has to be created, which means articles of incorporation, election of officers, annual meetings, annual report, all that kind of stuff for 2 units. It seems a lot of work to do for 2 units. So I'm trying to figure out what is the benefit? Why are you looking for this to be changed versus just leaving it the way it is? I mean, there's a lot of, you know, Anna reports, the financials have to be done by a third-party independent CPA. You know, there's all these extra things that have to go on once you change it to the CIC. And I had Joe's question too, is all these duplexes, are we gonna start having all these duplexes come up? What's the benefit? What's the upside of changing this? And if it's financial only, then how can the state say that we can't say no to that when we can't use financial for a variance, right? We can't let a financial be the reason for a variance on a piece of property. And so I'm just trying to figure out what's the upside here? Why are you asking for this change? Because I look at it as, you know, when I saw the address, I thought, here we go again, another concession, you know, for this property. And I mean, I know you say it's not about the property, but it really is. I mean, this group not once, not twice, 3 times said, don't do this project. And you went through and did the project. And, you know, other things came, a lot of time and effort, wasted money has gone into this, and now you come back again and now you want another concession on this project. And I just think it's crazy. I don't understand it. I don't, you know, we've disappointed a whole neighborhood, and now, you know, we think that we could do better. And we just keep doubling down on a stupid decision, and now you're asking for another concession. I'm just trying to figure out what the benefit is. What's the benefit to changing this ownership?
So, Mr. Chair.
Who are you directing the question to?
To whoever wants to answer it, I don't know.
I would love to answer it.
Good.
We'll have the applicant come forward.
Or would you like me?
Right to the
Up the
podium.
podium here.
All right, you had a lot of questions. Can you readdress them so I can
What's
answer
the
them?
benefit of changing the ownership to a CIC?
Well, to begin with, these are 2 single-family homes that were connected because of a change of subdivision. So how do you expect someone to sell an appraised property at $600,000 as 2 homes? Explain that first. I mean, how do you expect
But
somebody
it
to
was,
run?
I mean, this group said it shouldn't happen in the
This is the
first place.
first time I've seen this group, with all due respect. This is not.
Really? No,
This
it
is not the group
hasn't.
that was here the last city council hearing.
This is the planning commission, and we were all here at the time you came in at that.
Mayor Jim?
This is the planning commission.
This is the planning commission, this is not city
That's
council.
Okay, well, I haven't seen this group yet, so I'm not familiar with the
A
faces
few
here.
years ago, you were here,
Yeah.
when you originally came through, and this group unanimously said to the city council not to do the project, not to divide it.
Well, when we subdivided, it was because of what the city code and ordinance allowed. It was already zoned for a duplex, and that's what we applied, that's now what is being built. So how do you expect, how do you expect for 2 single-family homes to be sold as owner-occupied without them being a CIC plat? It's just-
That's what I'm
it's not
saying, that's a
possible.
financial
It's not a financial thing.
hurdle. You just said, how do you expect it to
Well, how
sell
do you
for
expect owners,
$600,000?
how do you expect somebody to live in a land that has a single-family home on it without it being purchased as a single-family home?
You were the one who built it. You
Yeah.
have to tell us that.
I built it with what I was permitted to build it for.
You direct the questions to the chair.
Sorry.
I don't want to get in the weeds.
I built exactly what I was permitted to build, if that answers your question.
Correct.
So, Mr. Chair.
It-
So,
Mr. Gill, Chris.
thank you, Mr. Chair. Just quickly I would caution you against going too far down, does this make financial sense, or why is that? You know, the variance standard on being solely a financial issue doesn't apply in this case. So why someone comes in to get a building permit to add an addition, which we think, you know, the objective person may go, that doesn't make a lot of sense. You're not ever gonna get your money out of those improvements to your house because of what you're proposing to do. That doesn't mean we don't issue the building permit for that. So I would really discourage you from getting too far into why are you doing this? You know, could there be more? There could be, but I mean, the fact that you've had these in your community for a long time and they haven't gone to a different sort of ownership structure suggests to me that there's not a burning, you know, desire to flip all these things into something else. The fact that one person chooses to do that, and again, believe me, I know there's a long history here, but the ownership change really doesn't get to any of the underlying questions of you know, ought to have this been built there. The reality is, 2-family dwelling on this structure, on this property, is a permitted use. That's being litigated. The court agreed it was a permitted use at district court level. It's currently under appeal. So that issue is being resolved in the courts. So far in the city's favor, that in fact it is a permitted use. So that's not here before the body tonight. It really just is, frankly, checking the box because your code says CICs are subdivisions, so it has to run through this process.
Okay, I have another question. It's not related.
Commissioner,
So if me and my neighbor decide, can we form a CIC? I know this one is on a single property, but can we, as 2 properties, form a CIC? I just wonder the limitations of a CIC.
Yeah. Mr. Chair and commission members, I'm not someone who forms CICs. So I'm not sure what all the different permutations are. I mean, typically when I see it, it's a single property that is being divided into lots, which then would normally go through a subdivision process, or a structural CIC like this, which typically does not go through a subdivision process.
Because I'm just thinking of this is kind of like a way to get around being a PD district because you don't have the land space for doing that. You know what I mean? Because now we have, as he cited, 2 homes, which technically wouldn't meet code because of the proximity of the garages and the lot lines, which it isn't a lot line because it's all on one property. So I'm just trying to wrap my head around what this actually is.
Could I just ask what you mean by doesn't mean?
Well, you said that this was 2 homes. So we have,
I mean, sorry to cut you off, but by definition, they're 2 twin homes, so it's a duplex, by definition.
okay, so then why aren't you treating this like a duplex? Why do you want it?
In what way?
Well,
All we're looking for, the only objective today we have here is for an owner-occupied home. That's all we're looking for, nothing more, nothing less, just like Dan said, and like Troy said, the state of Minnesota highly protects the owner-occupied for a dwelling that's a duplex. We're not asking for subdivision, we're not asking for, there's nothing in the development code that denies or supports denying a request for a CIC plat. That's the only objective we have here today. That's the only thing we're asking for is a CIC plat. Nothing more, nothing less, which the state of Minnesota highly protects, and anything that's denied by that is highly contrary to the Minnesota law, as Troy emphasized.
Mr. Chair, may I address the question?
Yes, Mr. Olson.
I think this was a question that the commission member had, is that we have duplexes all over the city where they're on one lot. You don't have to be on 2 different lots. One building, one single 2-family building can be on one lot. That's the situation here, and that's the situation with many. We have them all over the city.
I just remembered a question that Jill asked. Can I answer that for her about the property? So anytime I own some townhomes in other cities, and whenever there's more than 1 unit or dwelling on one property, so each property will get its own PID, property ID, and that's how the property taxes will be divided. And the same with your question about the actual ground. It gets divided as the PID. So each PID will have a fraction of the land. That's how that works. So the property taxes for 2 or 3 or 4 or 5 will get divided by that amount of dwellings on the property.
okay, then my only question, sorry.
Just for recording purposes, to identify who's speaking.
Sorry.
Commissioner Marisani, you got the floor.
So why do you want this property treated differently than the other duplexes in the city?
In what way?
Well, the other duplexes in the city don't have a CIC, so why are you requesting a CIC specifically when the other duplexes in the city have not requested?
Because, as I stated, we're just looking for a division of ownership, so that each owner can own each unit. Each unit is 3,300 square feet. That's not your typical duplex size. Each unit has 4 bedrooms, 4 bathrooms, full basement, 3 garages. That's not typical for a standard duplex that you have here in the city. So when there's something like this, you want it separated so you can have an owner occupied, so each owner can own each unit, which is not typical for a duplex.
Okay.
Any further questions?
I got one. Okay,
Commissioner Buck.
owner A wants his house to be tan. Owner B wants his house to be purple.
Okay? What's the problem?
Who's gonna stop him from doing it?
Nobody.
So one of them's gonna end up being ticked off if they don't like the other guy's colors?
It's his property, it's his business.
Okay,
Commissioner Hagel.
In other words, when you do this, there's no property, it's just a structure, correct?
That is correct.
How is that little structure in the middle then treated?
The garages?
No, there's a little, according to this picture, yeah, to fill the gap between the two structures. How is that treated?
That's a common area.
What do you mean common owner? Does
There's-
each one own half? Or?
Yes, each one owns exactly half. It's a
Exact-
common area. So when the articles of incorporation and the bylaws come out, there will be an agreement between both parties, who controls which, or if one owner controls both. There's only a few, maybe, actually, there's probably no common area because it'll go straight down the middle.
All right.
So,
But again, no property is involved in this, other than the structure.
that is correct.
So that retaining wall where they're between, are they then revert back to the owner of the
The
property?
retaining wall in the middle is actually on the east side property.
Well, there's 3 of them, aren't there?
Yeah. So there's a retaining wall on each far side and one in the middle.
And,
Yeah,
yeah,
there's only a retaining wall on the west side and one in the middle. And the one in the middle, I believe, is on the east side.
but the owners of those units would not own them.
They would own everything down the middle. Where the center garage ends is where they would own.
I'm a little confused because that retaining wall is on the end
Can you
of
pull
the
that picture up,
building.
Dan, on the monitor? Of the, yeah, in the center? Okay, so what's your question?
That little retaining wall on the east side
Okay,
and also on the west side,
okay?
does he own it or does the owner?
So the one in the middle
On the outward?
is owned by the east property because it's on the east side of the center garage. And the one on the west is owned by the house on the west.
Although it sits on property he doesn't own.
Mr. Chair?
No,
This guy owns that wall.
yeah,
This
so the
guy
property line
owns
is
that
past the
wall.
retaining wall.
Yeah, but
If
they don't
there's-
own the property.
They don't
somebody
own
else
Yes, no, they do.
property is what I'm saying. How-
Can I break in a second here?
Yes.
Sounds like we're not getting any communication going. Attorney would like to speak.
Yeah, so, Mr. Chair, thank you, and Commissioners, I think we have to be a little bit careful about, they own this wall and they own that wall, because, and again, I'm not a CIC expert as far as creating these things, but typically that's all common element, and then it's up to the organizational documents to assign who's responsible for maintaining what portion of that common area.
Okay, that's
So I
fine.
think that's when he's getting into dividing it down the middle. It's not dividing the property, it's, hey, you have to maintain that wall. I'll take care of this wall. But that's all part of what'll be worked out in the documents that are frankly private documents that they'll have to work out, and that any potential buyer of either unit would have to review and be comfortable with it. I understand if I buy this, and I'm buying responsibility for maintaining this part of the common elements.
Okay.
Did I get your question?
He's
Did I
got
take care
a-
of it?
Joseph has a question.
Commissioner Sears.
Maybe to help out on this, if this was built as a duplex on one lot, and normally just duplexes we rent out, there's no ownership, only the owner owns it and he rents out the 2 units. If this was built as a duplex, discussion is ended.
That's not correct.
No, if it was a duplex, because it would follow in our zoning laws, would be okay. In other words, we wouldn't have this talk if it was built as a duplex. But now we built it as a condo, and that's what we're having a little bit of a rub, because there's a division of property line.
Actually, there's not a division of property line. The only thing,
Building property line, structure line.
also, from what I understood and what Troy can confirm, we are not asking for a division of property line.
No, not of the physical property, the structure.
Also, we're not asking for that either. And Troy can correct me.
Troy.
So, Mr. Chair, this was built as a two-family dwelling, so this is a duplex on a single lot.
Right.
So the reason you're here this evening is because the owner has elected to seek a CIC condominium plat,
Okay.
which divides ownership of the units.
That's what I'm saying.
Right.
Yes.
So it doesn't affect, kind of anything else in the fact that it's just, and your point is right. It moves from one owner of the whole thing and two rental units.
We wouldn't be
Two.
here tonight.
Right.
We've been already done 2 years ago? In other words, it'd be
Well,
done.
we wouldn't be here tonight if the code carved out ownership-only CIC condominiums, basically. If it carved that out, if, you know, the original one should have come through, and it did, but, you know, that all went to the side, and so he abandoned that, instead went for the duplex approach, which was allowed, a permitted use under the code, and you're right, we wouldn't be here and you weren't here, you didn't hear that, because that was a permitted use, and that was just a matter of getting a building permit, and then that went forward. The only reason we're here is, you know, we just don't have that carve out in our code to say, you don't have to run through this process for a CIC plat that doesn't involve dividing the property.
That's how I was trying to, I'm on the same page as you were,
All right.
or you or I.
Commissioner Schultz.
So, yeah, I read the paragraph on the last page about the city attempting to amend the UDC, and that was not pursued. So we have been working on the UDC amendments, and addressing those. Is that something that can be addressed?
Yes.
Thank you.
Any other questions of the applicant? Would you like to make a statement?
No, I think we covered everything. Just just want to reiterate that the statement of fact is that we're not asking for a division of the lot. We're simply asking for an approval to divide ownership, owner occupied for each unit.
Okay. No further questions of the planner? Dan? Or the city attorney? Okay, appreciate it.
Thank you.
Now I'll invite public comment. Those who wish to speak, I have two here. Marjorie Lane. Pardon, I didn't hear you.
She yields to the next person.
Okay, I didn't hear you. Sorry.
She's yielding to the next person.
Yeah, I'm getting some feedback here.
Okay.
Dave Beeson. Say your name,
Okay.
address.
Hello, Planning Commission, thank you for your time tonight. My name is Dave Beeson. I live at 6603 36th Avenue North. Maybe to help the discussion, I do have some handouts for the Planning Commission. Do I give those to you, or?
Please give it to the planner.
These are excerpts from the UDC, so we'll be discussing those specifically. I'm opposed to this approval of this CIC plat application and request that the Planning Commission deny it, recommend its denial. This is simply not a permitted principal use in an R1 zone, with this R1 zone project. It's not permitted. What you have in front of me is an excerpt from UDC 505. Definitions, subdivision 51 provides that a definition.
Sir, do you have any more?
Sure. Oh, you're running short? Okay. That'll cover you. Sorry about that.
This will be part of the record,
Yep, absolutely.
just so you know.
Okay, what you have before you is section 505 definitions. That provides a definition that a dwelling, one family attached, means a building such as a townhouse or row house containing dwellings in which A, each dwelling is located on its own parcel, B, each dwelling is attached to another by party walls without openings, and C, each dwelling has a primary ground floor access to the outside. If this CIC plat were to happen, it would create one family attached dwellings, because each unit would have its own parcel of real estate. That's what this CIC does. It creates each unit is a parcel of real estate, and they're connected by a common wall. Therefore, by definition, it is a one family attached. Keyword is attached. You also have in front of you UDC section 515.17, table 3, permitted principal uses. You can see that it prohibits a one-family attached dwelling in an R1 zoning district.
You point out what page it's on.
Okay, I'm sorry, on page 2 of your handout. Get my handout. Page 3 of your handout. Page 2 is the beginning of that section. Page 3, you can see permitted principal uses, the third item down, dwelling, one family attached. There's a dash through it, which means it's a prohibited use in an R1 zone. Let's see what else. Also, the city attorney references Minnesota 515B1-106, as well as the applicant for its protection of CICs. However, they left out an important last line in that section, which says, I'll continue on where the attorney left off, in section 515B-106. Otherwise, no provision in this chapter, for chapter 515B, of this chapter invalidates, modifies any provision of any zoning, subdivision, building code, or other real estate use law, ordinance, charter provision, or regulation. So that was omitted from the city attorney's reasoning for the approval of this. What was I going to say about the... Therefore, 515B does not trump the UDC. The UDC controls. Yes, the UDC controls. It's clear in clear language. Also, as the city attorney stated, city needs to process and act on the proposed CIC plat under the present language of the UDC. Let's do that. Let's deny this application. As a one-family attached dwelling is prohibited, principal use in zone R1, the CIC application must be denied. The application should have been denied outright by the city planner. It never should have gotten to this point. It should not even be presented to this commission. So I respectfully ask that the planning commission recommend denial of the CIC plat application. Thank you all for your time and attention.
Any questions, speaker? Commissioner Strand.
I'm just wondering if the city attorney can comment on the missing statement that Mr. B said.
I'll be happy to address that when the hearing's done.
That's all I
Okay.
No questions? Thank you, sir.
Thank you all. Appreciate your support.
Next one is Marjorie Lane. Any other would like to approach? Seeing no one approaching the podium, I'll close the public hearing. Or should I continue to be on? Are you gonna make any testimony?
So, Mr. Chair, you certainly can close public input at this point, but the hearing can remain open. I'm not sure what your normal procedure is on that.
I'll leave the public hearing open.
Okay, but if I might, I'd be happy to address the points raised.
Yeah, you got the floor.
All right, thank you, Mr. Chair and Commission. So first of all, as to the definition that was pointed out of one family attached dwelling, it's important to note it says located on his own parcel. So that presumes two parcels, and that's not the case here. These are not separate parcels of real estate. These are units within a single structure on a single parcel of real estate. So these are not separate parcels. There is CIC structures that would allow something like that. I mean, you could probably conceive of something like that under law, but that's not what's before you tonight. So these are just different units. These are not separate parcels, and so that definition doesn't apply. As far as the sentence that, that was read from 515B. Absolutely, that's in there. And that's exactly what we would rely on if this was a real estate division CIC. So the ones that I've talked about, I've seen in the past where it looks and walks and talks just like any other subdivision. There are separate lots that are being created that are gonna be owned separately, just like any other subdivision, but they choose to do so under a CIC structure. Then absolutely, we'd bring them through this process. We would apply all the normal subdivision standards that would apply to it. So that's where you would rely on that sentence to say, yep, you're subject to our standards because you're dealing with a real estate subdivision, and so we're dragging you through this process to make sure you're compliant with their standards. In this particular case, because there are no standards that apply really just to this division within the structure, there's nothing to apply from the code, other than it falls under the definition of subdivision, so we gotta run it through this process. But there isn't a list of criteria or standards that have to be met for an internal division of units like this. So, sure, you can say the code applies, and I guess we'd have to because we're here tonight, but there's nothing in the code that actually applies. You know what I mean? I mean, there is no separate set of standards that applies. And then as finally, the comment about the planner should have denied it. Planner doesn't have the discretion to deny this. If that carve-out language was in the definition, CIC is not involving, excluding subdivisions, not involving the division of property, or words to that effect, the city wouldn't even be aware of this. This would have gone straight to the county and been recorded, because there is no town approval, it's gonna be city approval, there is no planner approval, there is no planner discretion here. So, in fact, there is no planner discretion to deny it outright anyway. This would have to come through the process. But you see my point, if that carve-out was in the code, which I think you'll see at some point in the future, that carve-out coming, this wouldn't even be a city issue. This would be purely gone to the county for recording.
Thank you. Any questions of the city attorney? Commissioner Marisani?
So we're saying that single-family attached dwellings, as long as they're on the same property, are a permitted use in an R1 district?
Mr. Chair, I'm not sure if I quite understand the question, but yeah, could you maybe explain a little more? I'm not sure if I quite understand your question.
Okay, so according to the applicant, the building is already built. They were originally supposed to be thought of as duplexes, but now we want a CIC to be on them so that they can be individually owned structures, building structures that are attached together. They're on the same property, and those are a permitted use in an R1 district.
Well, this building is defined currently as it sits today as a two-family dwelling. And with the CIC, that's sort of I would call it almost a layer on top of that. It's not a zoning layer. This is going to continue to be defined as a two-family dwelling. That does not change. The only thing that's changing is that now both units could be sold for an owner occupancy. Does that answer your question?
Is a two-family dwelling the same thing as a duplex?
Yes. There's no difference, I don't think. It's just a terminology. But our UDC always uses the term two-family dwelling.
Okay.
Just like it always uses the term one-family dwelling instead of single-family dwelling. So it's all, you try to keep the same consistent terms throughout the whole thing so that when you are referring to something, you know what you're talking about. So this is a two-family dwelling, and that will not change because of the CIC plat.
So then, two-family dwellings on a single property are allowed in an R1 district?
Correct.
Okay.
Yep. We have those all over the city.
Mm-hmm.
You saw when last month, when the UDC amendments were coming through, it's 3601, we recommended rezoning that to, it was zoned commercial, and that's a two-family dwelling. The city council recently went along with your recommendation, and they approved the rezoning, so that's going to be zoned R1, but it's a two-family dwelling, so.
Okay, then, if we go back to what Dave was saying, what is a one-family, or a dwelling, one-family attached then, that would differentiate it from a two-family dwelling, so that I understand the difference there?
Well, a one-family attached, that could mean like a townhome. For example, the one that comes to mind for me, unless you guys have, they may have better examples, but you may remember earlier in the year, the EDA property at 34th and Douglas. There was 2 townhome buildings that were approved for that development. To me, that would be one family attached, because each unit it's on its own separate lot, but they're all in they're 2 buildings, 4 units per building. That's a one family attached. That's what that looks like. There might be other examples of that, of how that's done, but that's the one that comes to mind for me. If you remember that one, that was just I think in April.
Commissioner Schultz.
So hearing both of you speak, so it seems like one of the things that needed to be defined was a parcel in this, and it, according to the parcel of real property means the smallest separately segregated unit of land having an owner. Just so in my own mind, because this seems to be part of what constitutes a dwelling of one family attached. Is that correct?
Mr. Chair.
Troy.
Thank you, Mr. Chair. Yeah, again, it's that land piece of it that distinguishes it, you know, the parcel, the property, the real estate. So that example, if you own the real estate and the building, even if it's connected by a common wall, you own that slice going up through that, and then the other person owns the real estate and slice going up through the building. You know, this isn't that. The real estate is one, and so these are kind of, just like, again, if you lived on a 5th floor of a 80-unit condo building, you own just that unit. You're not owning any of the land individually as part of that unit. You just be inside of the walls.
So then subdivision 51A would not apply in this situation, is that what you're saying?
Correct, because they're not on their own parcels of real estate, of land.
Commissioner Marisani.
So since they only own the inside of the 4 walls, does this mean that they don't have to take care of the grassy areas?
No, Mr. Chair?
City Attorney Troy.
Thank you. So just to respond to that, no, I mean, there's still a duty to maintain. That's those documents I was talking about how you divide that up. If it was a larger unit, they would have a separate entity that would probably maintain the property for them. But given it's only 2 units, they probably are gonna divide up. Like I said earlier, you know, you're responsible for maintaining that wall, I'll maintain this wall. So there's still maintenance done. It's just, it's by agreement rather than by property line, because they're generally responsible for the entire property. It's that paper, that the covenants that go along with that and the organizational documents that'll divide up who's responsible for what specific maintenance activity.
Follow up?
Well, I just want to, so then this is a way to get around, I don't know how to put it. This is a way of kind of getting around just having a single family unit on a property and instead having 2 owners for a single property then, right?
So, Mr. Chair, I don't know that this is really a way of getting around anything. It's just an alternative way of owning real estate. And so, again, I'm part of a different CIC that we don't own anything. We all own shares in all of the property, but none of us own any particular lot within that. You lease lots. So there's all kinds of different ownership structures under the CIC model. This one is again these units. So it really is. Think of it really just as ownership, a change in ownership structure than anything to do with real estate.
Okay.
Any further questions? Any further statements? Sure.
And Dave Beeson, 6603 36th Avenue. couple comments. To imply that this is still a two-family dwelling is nonsense. It's not. It's not a duplex. We're splitting property. The fact that we divide a unit, there'd be two units, and those would be separate parcels of real estate. You don't have to separate the land to be a parcel. It's a piece of real estate. And even from the 515, Minnesota 515 definition, each unit and its allocated interest in the common elements constitutes a separate parcel of real estate. So we're talking about a single-family attached. We're talking about ducks. That's what this is. This is that kind of duck. It's not, all ducks are not all the same. And this is a single-family attached. Separate parcel, common wall. That's what it is. So it is prohibited from use in an R1 zone. So I think seems like you guys are all getting that. We can twist words all day long, but that's the duck this is. So I again ask that this be recommended for denial. So thank you.
Question? Member Sani?
With things structured like this, does this meet the density requirements of the area, or does it exceed the R1?
It meets it exactly. It's 3 to 4 units per gross acre, per net acre. This doesn't increase or decrease the density. Yeah, so that, I mean, I'll answer the question, but it does not change what's already here. Mr. Chair, I'd like to just say that condominiums are not an unusual type of ownership. I live in a condominium as well. My condominium was formed in 1980. The one I live in, it's 18 units. The building itself was built in 1890 as row houses. And it survived as row houses for several decades, and then in 1980 it came and the owner bought it and converted it into a condominium. So each unit, I live in one, each unit is owned just inside the box. I own that. I take care of it inside the box, and then the condominium association takes care of the grounds, makes sure the snow is shoveled, the grass is mowed, the parking lot is kept up, all that stuff. So it's not an unusual form of ownership. I don't know. We don't even know how many are in Crystal because we don't keep track of that sort of thing. We haven't had one of these since I've been here, but that doesn't mean that before this was added to our zoning code that these were not a routine thing that were just being sent to the county for approval. I don't know how long this has been in our in our zoning regulations. It was when we created the UDC in 2018. It was there. It's been there prior to that, this regulation, but we don't keep track. We have no idea how many condominiums are in the city. There could be quite a few, but it's not an unusual type of ownership.
Commissioner Marsani?
So this is just for personal information. So you say there's an association. So is there going to be a separate third party that's not the owner of either of these two buildings that will be the association, or will the association just be the two people who own the buildings?
Well, from my experience, the association is made up of all the owners. In this case, it's two, and they have an attorney draw up these declaration documents that decide who takes care of what and all the things that Troy has talked about earlier. In my experience, with my condominium, our association has hired a management company to administer the day-to-day financials and hiring of lawn care and all that. But in this case, since it's only 2 units, I wouldn't think that they would go that far, but I can't really speak to that. But I think that these things can be a little different depending on the situation. As you said earlier, this is only 2 units, so they probably maybe don't have an elaborate they don't need to have an elaborate management structure as opposed to maybe a 500 unit condominium. That would have that.
So since there are only two of them, if one of the guys says, you keep shoveling snow onto my driveway and has a problem with it, and the other guy says, put up with it, I mean, it's a, I vote against you, you vote against me type situation, so how does that work out? I guess I'm not that familiar with.
I'll defer that to.
So,
Attorney
Mr. Chair
Troy.
and Commissioners, I mean, that's something that they'll have to work out. Just like I have an easement across your property, I throw snow from my easement onto your land, you say, stop that, how does that? I mean, basically, it comes down to, they have to work that out among themselves. That's not really a city issue.
Okay.
So they'll just have to work that out. But since I have the floor, if you don't mind me, just a couple of things. One, I realize it sounds like I'm an advocate for advocating on behalf of the applicant. I'm not. I'm here on the city's behalf. I'm just trying to keep it in a proper perspective here. So as this works its way through the process, we have a good record that's defensible if anything gets challenged down the line. So that's my only role here. Frankly, I don't know this gentleman. It frankly doesn't matter to me one way or the other. I'm just trying to tell you, I'm just trying to keep it as a role of city, trying to create that record, keep the understanding as clear as possible about kind of where we're at in this legally. Finally, I'd like to point out unit. Again, these are referred to as units. In a condominium is defined as means a portion of a common interest community, the boundaries of which are described in the common interest community's declaration, and which is intended for separate ownership or separate occupancy pursuant to proprietary lease. Again, it's the idea of defined unit, and the units are defined typically from the walls in. So if I break my drywall, that's part of my responsibility. If the bricks fall off the outside of it, that's the common, that's not my personal responsibility. Now, again, a 2-unit, it kind of blurs that line a little bit. But the point is, unit is defined, again, my lease that I have in my little cabin slot, I don't own it, I just have a lease on it. That's a CIC, that's a cooperative CIC format. So my point is there's a lot of different types of CIC structures of ownership. This one is simply separate ownership of a unit, not of separate real estate.
Any other questions?
I just want to.
Commissioner Marisani.
So does this mean that because I own it, I can rent it out like I would my house if I wanted to?
Mr. Chair, pursuant to whatever the organizing documents, my condo, I can't lease it out. I'm prohibited by my documents to say I can't. But there are others that made a lot of money during the Super Bowl time down here leasing their condos out because there was nothing prohibiting them from doing so. So that would be subject to your organizing documents and then whatever the city ordinance deals with as far as short-term rentals.
Okay.
Any further questions?
Mr. Chair, may I approach one more time, please?
Yes? Still have the public meeting open.
All right, good. Dave Beeson, 6603 36th Avenue. I just heard earlier that these were going to have separate PIDs. That's separate property. That's a separate piece of real estate. So this is double. I am hearing double talk here. It's a separate PID, property identification, whatever it means. And this discussion about their condo, the attorney's condo, the planner's condo, has no bearing on this. This is an R1 zone. They're in something other than an R1 zone, which allows these condominiums. R1 does not, so discount their condominium experience because it doesn't apply here. And they have separate PIDs, so it seems pretty clear. But anyway, I appreciate your support, and I'm just getting a completely different read on this whole question than this side of the room. So, thank you very much.
Thank you. Any further questions?
Yeah,
Commissioner Sears?
this is for the attorney. Your letter that you wrote, first, the last sentence of the first paragraph. We'll give a count of 5 and then I'll start. Maybe people get a chance to read it. 5 is up, okay. The definition of the subdivision, an owner proposing to establish the condominium plat, they are required to apply to the city for approval. Now, that means we've got a choice. Is that how am I reading that? In other words, we've been talking about this, there's state statutes, and there's no firm yay or nay of whether or not it can be enforced. You know, it's kind of like, there's a little gap in our zoning laws. So, but it says here, apply to the city for approval. Well, that means there's two bodies here. There's a planning commission, that's body one, and then body number two is a city council. Now, if we say nay, and of course, it's recommendations, and then it goes to the city council, and they can overrule us, because they have in the past. I've been here the longest, 22 or 23 years, so there's been a few times where they've overruled us. But am I reading that correctly, what was written? I mean, apply for approval.
Right, so Mr. Chair, that's because there isn't the carve-out, the only way you can seek or go through this process is to make application for subdivision, a CIC subdivision approval, go through the planning commission, which we're here tonight. Yes, you make your recommendation. So, you know, I guess that goes back to the question, do we have to vote on this? Yes, you need to vote on it because we need to take it to the next step. But to the extent of, well, if we don't approve it, that was part of the reason why I talked to, or spoke about a quasi-judicial decision. So you've been here 22 years or whatever you said. So you know the difference between policy and quasi-judicial, meaning you need to have stated reasons other than neighbor opposition as to why you'd be denying something. So to the extent you're inclined to say, I just don't like this, you need to have articulable reasons that you state on the record why. And frankly, I don't know what those could possibly be. Because, you know, there was talk about me twisting this. There's not a matter of twisting this. This is an allowed, the structure is already allowed. There's nothing to do about the structure itself. This is purely ownership issue. And again, we ought not even be here. The city ought not be involved in this at all, but for, frankly, a glitch in our code that
I said
swallows
that.
it.
I didn't say that. There was a small crack or a glitch. I said I'm aware of it. Okay. I'm just wanting to help make it clear for everybody. If there's no rules or statutes that says that it can't be done, we can't put our wishes onto something that has no, I just said, wait, if the state or the county or the city has no regulations, then we can't say that it can't be done.
Mr. Chair, that's my point. I don't see a basis which you could articulate that
Right, I
we
know.
deny this because it violates standard number 3. There is no standard number 3 or 1 or 2 or 8.
Commissioner Schultz.
So I go back to 20 minutes ago. So if we modify the UDC, that could change the outcome of this approval. Is that what I'm hearing you say?
So, Mr. Chair and Commissioner, this would, if the change that was proposed before had gone into effect, this wouldn't be here tonight. The city wouldn't even know about it. It would have just been recorded at the county recorder's office. You wouldn't even been aware of it. So what this means is that if that code provision changes in 6 months, a year, whatever the case may be, any proposed CIC condominium that doesn't involve the division of real estate would just bypass the city and go to the county.
But if the UDC is modified to address a situation like this differently than the previous proposed change in the UDC, we could have a different outcome.
Mr. Chair and Commissioners, keeping in mind that the statute prohibits you from treating them differently than other, two-dwelling homes, I have a hard time thinking about what those standards would be, because you're trying to then condition or dictate ownership issues, which I think you get pretty strong pushback. I've gotten pushback from attorneys on that, citing that same language that I cited in my memo, saying you can't touch this, even though it's a full land division subdivision. I said, no, we're gonna touch this, or, you know, you're running this through the subdivision process. So if it truly is a condominium, unit only, no real estate subdivision, I just don't see where this, a city, even trying to be creative here, could come up with regulations on that.
Thank you for clarifying.
Sir? Yep, applicant, come forward.
I'd just like to address a couple comments. The first one regarding the PIDs for the property, that's not something that I created or I chose. That's something that's just done by the way protocol works for townhomes or more than one unit on a property. So that's something that's gonna happen regardless. So if I change my mind tomorrow and decide I didn't want a CIC plat, the way these houses are built, there's nothing that can change the way they are, and it's totally permitted, and there's nothing in the structures that's against the city code or what I was permitted to build. So I want to make that very clear that our objective here has nothing to do with the way the structure is built or how the structures are sitting or anything in between that. So just want to, again, reiterate that, like Troy said, which I confirm that I've never met him before today, and I have my own attorney that's working on this with us, that our only objective is to get owner occupancy for each unit. Nothing to do with the dwellings or the structure. And the only nonsense that's been, since the beginning of the construction process, I've been getting nonsense complaints and subjugated to nonsense complaints to the city about everything from the beginning to the end. Trying to make my life difficult just because I bought this property and I decided to build and develop this property. And there's been no justification as to why they want to make it difficult for me to do what I'm permitted to do. And that's exactly what was built on this property, is what I was permitted to build. So, that's all.
Just one, Mr. Chair, just one real quick comment about PIDs or PIN numbers. That's purely a tax tracking method. They came up with that to be able to figure out, you know, where to send the tax statements and all that. I can have 3 parcels of property, all have the same PID number. There's still 3 separate parcels of property, but I just get one tax statement for all 3. So it's a property tax system of the county computer system. It's not, it doesn't designate necessarily that stands for a separate parcel of real estate.
It's like I have 2 electrical boxes on one house.
Yep.
Any further questions, comments? Anything from the city? I'll close the public hearing. Do we have a motion before us? Approval or deny of the applicant? Mr. Buck,
I'll move to approve to recommend approval to the city council for subdivision CIC plot application at 6613 36th Avenue North.
do I have a second? Commissioner Sears?
Second it.
Commissioner Sears seconded. Any further discussion? All those in favor of the motion say aye.
Aye.
Those against say nay.
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 Call roll call.
Sears?
Aye.
Strand?
Nay.
Schultz?
Nay.
Silton?
Yay.
Johnson?
Aye.
Buck?
Aye.
Heigel?
Nay.
Mayor Stani?
Nay.
Mr. Olson, did you get me down as a yay?
I did.
Okay.
1, 2, 3.
4 to 4.
It's tied.
So, Mr. Chair?
So the motion fails.
So then, with the tie, this then just gets forwarded to the
Right.
city council without recommendation.
Right.
I've never seen that happen before.
That concludes. It's marked down as a tie.
I did, yes.
Okay. Thank you. Next is old business, we have none. New business, none. General information, city council actions on previous planning commission items.
Yes, for the conditional use permit for the daycare at 7057th Avenue, that was approved by the city council just as you recommended. And then for the UDC amendments, including the property rezoning at 3601 Douglas, that was also approved by the city council just as you recommended, with two things removed. The first would be the rezoning at 3443 Douglas. That was the first thing you removed from the ordinance. And then the second thing you removed was the definition of gross density. So those were both taken out, and the city council approved it with those omissions, or those deletions, I should say. And that will go into effect in mid-December, that ordinance.
Okay, thank you.
Planner Olson, any word on when the construction on the daycare may start?
It's going to be a while, I think. They have some work to do. They haven't given me a specific timeline, but they have to, there's tenants there that they have to get out in the building. So that's probably going to take them a while, and then they'll, they haven't applied for a building permit to do the interior renovation, so I don't know when that will come, but they haven't submitted that yet. They have up to a year to submit it.
Thank you.
Commissioner Sears.
I want to say thank you. Thank you. You did well trying to explain it. I got on board or understood right away, but thanks a lot. But one of the things I've learned through the years is that, contrary to popular belief, we have not much say in a lot of items because they're state statutes, and we're not well aware of them. And so, thus, you know, whatever we try to do, we're already hemmed in. Like here, we found a little crack, you know, in the zoning law, but you can do, you know, for lack of words, it's the Wild West days, you know, anything can go. Just because nobody has spent time, you know, to close the gap. So, but I do say you did well, okay? You did well, and I understand what you were trying to do, and I was trying to help too, that you clarified two items. One is money. I can't say, well, geez, you're not making enough money, or it's too much, or the style. And you said, you know, you incorporated. That was good.
Thank you.
But otherwise, it was a foregone conclusion, you know, in that. That's all I'm saying. But you did well presenting it. City, a lot of our city codes, we have nothing to say to. You know, the more and more I've been at this and other meetings, state law is already destined the outcome. Okay? Let's go. Okay, I'm done.
Okay, next item is an update from the council liaison. Do you have anything, Therese?
Well, interesting conversation tonight. You guys all had really great questions. Update from the council, the wine thief store is supposed to, on 36th and Douglas, is supposed to be open before Christmas. That's pretty exciting. It's been empty for a long time. This morning, there was the ribbon cutting on where the El Loro used to be. It's another Mexican restaurant, and the name is?
Tequila Town.
Tequila Town. That was this morning.
Enthusiastic.
I wasn't able to attend, but I hope it was good. We spent a long time last week working on the budget going forward, which we'll vote on in December. So, any questions for me?
Any questions? No? Doesn't look like
Okay.
it. Thanks
Thank
for the
you.
report. Review of likely agenda items for December.
Yes, we do not, I have not received any applications yet. The deadline for applications is tomorrow, so we could get an application in tomorrow, and I would let you know.
Thank you. Next item, open forum. Anybody have anything?
Yeah, I've got something. This is probably for developer Sutter. I saw a news article just this morning saying that the feds, this is in regards to light rail, the feds have changed the calculation used to determine average density or average ridership. And when we ran the application for Blue Line, it decreased by 30%. Have you heard about this?
Yes, I would say this is one of those news stories where the headline grossly misstates the actual facts. So,
The article I read that followed didn't do much to dispel that either.
well, I think it was better or less misleading than the headline. So what happened is the feds changed the methodology across the country to use the same ridership model. And yes, using that model, the forecast ridership of the Blue Line is about 30% what it was before the pandemic. But it's not because of the pandemic, it's because, or it may only be partially because of that, it's primarily because the methodology changed. The last model run they did was before the pandemic when the route was going to go in the rail corridor. So the point is this 30% reduction, it's like nationwide. All ridership calculations are different now, or estimates are different now from what they were back when everybody could use their own model. The FTA had to accept the model, but every regional project came up with their own model. Now the FTA, Federal Transit Administration, said, no, you're not going to get to use your own models anymore. You're going to use our model across the country for apples to apples comparison. So that's the primary reason.
Okay.
One other point that you should be aware of, though, is even using Metro Transit's old model, the one with the higher number, the actual ridership of both the part of the Blue Line that opened in 2005 or whenever it was, and the Green Line that opened in 2010-ish, both of those, the actual ridership has exceeded even Metro Transit's own model. So you read that headline, and I wish Metro Transit would have got out in front of this because you knew how it was going to get spun. But the reality is, it's not what they're making it sound like. It doesn't mean that ridership is plummeting because of something. It's just a different way of estimating it, and even the old higher models, both the actual blue and green lines exceeded those ridership estimates. Not by a lot, but they did exceed them, so. I don't know what that all means, but.
Thank you, John.
Yes.
Any other? Well, we're open for adjournment. I'm gonna make a
I make
motion
a
to
motion.
adjourn.
I make a motion to close this shop.
I second it.
Commissioner Sears makes a motion, Commissioner Schultz seconded. All in favor, say aye.
Aye.
Nay, explain yourself.